And we're going to talk this afternoon, about legal issues when writing about real people, particularly focusing on the right of publicity cases and whether they pose a threat to authors. There have been recent attempts, both through litigation and statutory amendment, to expand the scope of the right of publicity in ways that restrict publishers and authors, and which, in our opinion, violate the First Amendment. I'm talking in particular about the right of publicity with respect to writing about, naming, or depicting real people. What we have here is the interplay between state law, which is not the same in all the various states, and the First Amendment. Before we talk about some recent cases in New York and California, both of which are significant for this purpose, let me give you a little bit of background. There we go. What is the right of publicity? The right of publicity is the right to protect one's right to control the commercial use of one's identity and story or history. It's fairly recent. In the Highland Labs case, which involved trading cards, sports trading cards. Back in 1953, the Federal Court of Appeals in New York looked ahead and really saw that and said that we think that in addition to and independent of the right of privacy, which in New York derives from statute, which Richard is going to talk about, a man has a right in the publicity value of his photograph. That is, the right to grant the exclusive privilege of publishing his picture, and that such a grant may be validly made in gross without accompanying a business. This right might be called the right of publicity, for it is common knowledge that many prominent persons, especially actors and baseball players, far from having their feelings bruised through public exposure of their likenesses, would feel sorely deprived if they no longer received money for authorizing advertisements popularizing their countenances displayed in newspapers, magazines, buses, trains, and subways. We then had two cases in the Supreme Court, Time versus Hill, which involved the recounting of a crime in both a book and a movie called Desperate Hours, and Zacchini versus Scripps Howard, which was a television portrayal, not a portrayal, really a video of Mrs. Zacchini was shot out of a cannon at a circus, and his entire show, which is brief, from the time he got shot out till he successfully landed, was filmed, and the court said that was taking something that he owned. Now, it's state created. In some states, it's common law. In some states, it's statutory, and in some states, such as California, which we'll talk about, is both. And the scope of the right varies from state to state. In some states, for example, it covers deceased persons for some period after their death. In other states, it doesn't. In some states, it covers prescribed depictions, which we'll talk about. And finally, as I said, this is a balancing of the First Amendment and the right of privacy. They're various tests of looking at it. One of them really is what's called the transformative use test, which is to say whether you are simply taking that person's identity or story and sticking it in, or transforming it to something that involves the author's creative abilities. That's a concept that moved, many of you recognize it probably from copyright law, and it's moved over. The other is the predominant use test, which is whether the work predominantly exploits the commercial value of an individual identity, or whether it goes beyond. One last point, which is important, it was mentioned in the Highland Top case, but I want to mention it again, is this is not a right that is limited to celebrities, but also covers regular people. And you'll see in the early New York case, which Richard is about to talk about, the person there was just a good-looking young woman who happened to have her picture taken by a photographer. Okay, Richard, if you would talk about the New York cases.
Thanks very much, Michael. Michael spoke about some of the more recent developments in the right of publicity. I'm going to go back in time somewhat and go back to 1902 to the case which is the foundation of the statutory right that led to the foundation of the statutory right of publicity in New York. In 1902, the New York Court of Appeals held that there was no common law right of publicity in New York, but as we'll see in a minute, invited the New York State Legislature to enact a statutory right. The facts of Roberson against Rochester Folding Box are as follows. Abigail Roberson had her photograph taken. Without her consent, she found that Franklin Mills Company, which milled and sold flour, used her photograph, a lithograph of her, on its advertising and packaging. Franklin Mills manufactured and distributed about 25,000 boxes of flour, and that contained Ms. Roberson's portrait, and above the portrait was printed the title Flour of the Family, and the name Franklin Mills Flour appeared underneath. Ms. Roberson sued, claiming that the use of her image to sell flour violated a right of privacy. The lawsuit was based on what became a very prominent law review article by Warren and Brandeis on the right of privacy or the right of publicity. And the court made note of that article, but said that was not the law in the state of New York. The Court of Appeals noted that there was no claim of libel, saying that the likeness was said to be, quote, a very good one. And then it included the odd statement, quote, such publicity which some might find agreeable is to plaintiff very distasteful. So the New York Court of Appeals thus held in Roberson that there was no common law right of publicity and expressed concern about an unlimited common law right, expressed concern of what would happen if the Court of Appeals were to establish a right as a matter of common law, that it could not be restricted, it could not be defined, and the court said that was not the way to go. But the court issued an explicit invitation to the legislature, saying the legislative body could very well interfere and arbitrarily provide that, and here's the key language, no one should be permitted for his own selfish purpose to use the picture or the name of another for advertising purposes without his consent. That invitation to the New York Court of Appeals brought a response from that invitation by the New York Court of Appeals brought a response from the New York legislature, which in 1909 enacted Section 51 of the New York Civil Rights Law. The provision is very straightforward, fairly short. Any person whose name, portrait, picture, or voice is used within this state for advertising purposes or for the purposes of trade without the written consent first obtained, as above provided, may maintain an equitable action to prevent and restrain the use thereof, and may also sue and recover damages. Now let's unpack that. There's a prohibited subject matter, the name, portrait, picture, or voice. There are prohibited uses for advertising purposes or for purposes of trade, defined by the courts to exclude fiction and other expressive works. It must be without written consent, and as construed by the courts as a newsworthiness exception and an incidental use or advertising exception. The statute thus follows very closely the prohibition envisioned by the Court of Appeals, a prohibition on the use of the picture of the name of another for advertising purposes without consent, and the further limitations that were developed, the newsworthiness exception, was designed to state that the statute permits the unauthorized use of a person's name, picture, or portrait when the publication concerns, quote, newsworthy events or matters of public interest, unquote, unless the use has no real relationship to the news story or is an advertisement in disguise. Incidental advertising or marketing materials have also been permitted by the courts, and that's something that's of enormous importance, of course, to authors and publishers, because if a photograph of the subject of a biography appears on the cover of the book, most likely the cover of the book is going to be used in advertisements for the biography. And that's advertisement, but it's incidental advertising to a protected use, and that's been held explicitly permitted by the courts. But after 1909, there was trouble on the horizon. First, in 1916, what became a decade later a very important event for the right of publicity, Olivia de Havilland was born. Michael will discuss the Olivia Havilland case in California after I conclude in a few minutes. A half century after the 1909 enactment of the Civil Rights Law, Section 51, the New York Court of Appeals decided a case called Spong against Julian Messner. The court held the publisher of a book called The Story of Warren Spong could be held liable because the book used, quote, literary techniques of invented dialogue, imaginary incidents, and attributed thoughts and feelings, unquote, which dialogues which the author knew never occurred. And the Court of Appeals focused on that falsity, that intentional falsity, and held that since the defendants admitted knowing falsification, even though there was no defamation, Spong could have a cause of action. Spong ultimately obtained a $10,000 verdict and an injunction. Spong is a dangerous case. It's never been overruled. It's never been completely embraced by later cases. And in the face of Spong, there have been numerous cases over the years which have held that Section 51 is not violated by works that are based upon fictionalized works of real events. Among the works that have been the subject of such litigation are Dog Day Afternoon, 6 Degrees of Separation, and many others. So where are we today? Christopher Porco was convicted of murdering his father and mother with the same axe. Murdering his father, seriously injuring his mother, who survived, both with the same axe. Lifetime created a movie called Romeo Killer, the Chris Porco story, which was a fictionalized account of the murder. Porco, from his prison cell, where he's serving a sentence of 50 years to life, filed a pro se complaint without a lawyer under Civil Rights Law Section 51, seeking to enjoin distribution of the movie. In 2013, the trial court granted a temporary restraining order against the broadcast of the movie, which was then vacated by the Third Department Appellate Division, which is the intermediate appellate court in New York. The trial court then dismissed the complaint and Porco appealed. 1 year ago, in 2017, the appellate division reinstated the complaint. And here's what the appellate division said in reliance on Spong. The scope of the newsworthiness exception to liability, however, must be construed in accordance with binding Court of Appeals precedent. The Court of Appeals has held that statutory liability applies to a materially and substantially fictitious biography, where a knowing fictionalization amounts to an all-pervasive use of imaginary incidents, and where a biography is, quote, nothing more than an attempt to trade on the persona, unquote, of the plaintiff. So Porco essentially followed Spong, a 2017 decision that refreshed what many had hoped was a 50-year-old and long-forgotten decision of Spong, and made it a danger and a risk to authors today. That brings us to Lindsay Lohan and KarenGravano, and a case that was decided by the New York Court of Appeals at the end of March, just 1 month ago this year. Lindsay Lohan brought an action against Take-Two Interactive Software, the creator and publisher of Grand Theft Auto 5. Lohan contends that the game has characters that reflect her likeness and persona, and that the images bear a sufficient resemblance to her that they should be considered her portrait. These images appear in two different ways, and this is getting into the weeds in the case, but it ends up having importance later on. There's a character in the active part of the video game that Lohan says is her, and there are two still screens called transition screens that are displayed when the video game is loading that also contain images of Lohan, images that Lohan claims that are her, and that Lohan claims reflect her likeness, persona, or portrait. One of the transition screens was also used as an advertisement for the game. KarenGravano, a reality TV personality, also sued Take-Two, asserting that one character in the active part of the game was her, or was based on her.
You should say which is which.
What the screen is before you is on the left-hand side is an actual photograph of Lindsay Lohan, and on the right-hand side is the image of Lindsay Lohan that appeared on the transition screen and also in an advertisement for Grand Theft Auto 5. The Appellate Division First Department dismissed the complaints after the trial court had upheld them. And the Appellate Division First Department, and here that's the Appellate Division, as I said a moment ago, is the intermediate appellate court in New York. The Appellate Division issued a strong decision under the Civil Rights Law, limiting the scope of the Civil Rights Law in accordance with its language to name, portrait, or picture, making clear that the video game itself was protected and that the video game itself does not fall within the statutory definitions of advertising or trade, and dismissed Lohan's claim for the advertising, saying that the use of the character in advertising was incidental or ancillary to the permitted use. A strong decision which strengthened the precedent under the Civil Rights Law. The Court of Appeals granted a discretionary right of appeal. In New York courts, sometimes one can appeal as of right, and sometimes the appeal is discretionary. The New York Court of Appeals decided to take this case. It didn't need to do so, and this is something that caused grave concern among many who were observing the scope of the right of publicity and want to make sure that the right of publicity is construed in a way that it doesn't intrude on the First Amendment. In the Court of Appeals, Lohan and Gravano argued for a radical and unprecedented expansion of Section 51, both in terms of the subject matter, name, portrait, picture, or voice, and the prescribed uses, which are limited to advertising purposes or purposes of trade. Lohan and Gravano argued that instead of limiting it to portraits, they should also cover the image, the likeness, or the persona of the person supposedly portrayed. And Lohan and Gravano argued that the purposes of trade should be construed to include any work, any creative work, as long as it was sold for compensation. So as long as an author sought compensation for work, and as long as a publisher sold a book rather than distributing it for free, according to Lohan and Gravano, it was being used for purposes of trade. The Court of Appeals affirmed dismissal of the complaints of Lohan and Gravano, but it did so on very narrow grounds. First, in Lohan and Gravano's favor, it held that an avatar in a video game may constitute a portrait, even though it's not a photograph, even though it's created by an artist. The Court of Appeals held that a graphical representation in a video game may constitute a portrait, and that's not only in a video game, but in like media. But then it went on and made a finding of fact that the images in question do not constitute a portrait, and therefore dismissed on that basis. The Court of Appeals then did not reach Lohan's contentions regarding the advertising or trade element of the civil rights law, didn't even hold that whether video games were protected because they're video games, but simply held on the basis that these images were not portraits of Lohan and Gravano. A great victory for Take-Two Entertainment. The case is dismissed. It's the end of the case, no further proceedings, no recovery by Lohan and Gravano, and a modest victory for the First Amendment. The Court of Appeals recounted the case law over the years on the right of publicity and on Section 51, and in an odd paragraph made a distinction between its own decisions and decisions of other courts. The Court of Appeals noted with the phrase, "we have deemed," its own decisions, which held that it was non-actionable to use a person's likeness with respect to newsworthy events or matters of the public interest. And then the Court of Appeals noted that other courts have explicitly concluded, and the Court of Appeals then went on to list, and it's on the screen before you, the broad range of creative works that have been held outside the scope of Section 51. Humor, art, fiction, other creative works. It's odd that the Court of Appeals used that language. It was a great opportunity for the Court of Appeals to not only cite those other courts, but to embrace that broad construction of works that are excluded from Section 51, and thus a strong construction of the First Amendment. A strong respect for the First Amendment's restrictions on Section 51. So it was a missed opportunity for the Court of Appeals. And what does the Court of Appeals say about the Spong case or the Porco case? Nothing at all. Neither case is cited by the Court of Appeals. Neither case is discussed by the Court of Appeals, even though both of those cases were discussed in the briefs of one or both of the sides in the Court of Appeals. So the Court of Appeals decision ends up not doing any damage to the law, not doing any damage to the First Amendment, but not being any great help for the First Amendment either. And that's where the law is in the state of New York. I'll turn it back now to Michael, who'll discuss the de Havilland case in the state of California.
I am back. In California, California has both a statute with respect to right of publicity and a common law right of publicity, though if one looks closely at the cases, they've sort of merged. The statutory right, which is on the screen, Civil Code 3344, is in many ways similar to New York Section 51. It lists prohibited subject matters, though I should add that it adds likeness. One of the things that Lohan in the New York courts tried to argue is that somehow in Section 51, likeness should sort of would have come in through the years, but it hasn't, and that really limited her claim. Prohibited uses are similar without prior consent, and it exempts, the cases exempt expressive works, but only if they are transformative, which brings us to the de Havilland case. Olivia de Havilland is 101 years old. She, in fact, went before the court and asked that did not physically go before the court, her lawyers went before the court and argued that the case should be expedited because of the fact she's 101. But she was complaining about a movie, which was in a series of pieces shown on FX Network, which was a documentary called Feud, Betty and Joan. Joan Crawford and Betty Davis, thank you. And she argued that it violated her right of publicity in that the movie included false depictions of her and depreciated the value of her name and identity. She appeared in 6 episodes of the movie and 11 promotional advertisements, even though she was not one of the 2 persons named in the title of the movie. Her consent was not obtained. There was an allegation in the case that consents were obtained from some of the other people, though that's not entirely clear. The complaint highlights de Havilland's reputation for being a classy person, for not gossiping about fellow actors, and contrasted this with her portrayal throughout the movie, where she was making negative, vulgar statements about her sister, Joan Fontaine, repeatedly referring to her as a bitch, and Frank Sinatra, which statements were not verbatim to statements which were actually made. And therefore, she says this makes her appear as a hypocrite. The movie also features an interview at the 1978 Academy Awards, and the interview never actually happened. The trial court denied defendant's motion to dismiss, holding, among other things, that the work was not transformative since the docudrama attempted to be and appeared to be accurate. As the quote said, defendants admit they wanted to make the appearance of plaintiff as real as possible. There is nothing transformative about that. It then went to the Court of Appeal, which is the California Intermediate Court, similar to the Appellate Division here in New York, and that court reversed in a very strong First Amendment opinion. And the court said that the movie is speech that is fully protected by the First Amendment, quote, which safeguards the storytellers and artists who take the raw materials of life, including the stories of real individuals, ordinary or extraordinary, and transform them into art, be it articles, books, movies, or plays. I presume that's a nice way of describing what you all do. And they said it was transformative because it doesn't derive primarily from de Havilland's fame, but rather from the creativity, skill, and reputation of Feud's creators. In that sense, it's like some of the New York cases, which we haven't talked about, which look to the creative element in the work. And they also found it wasn't false right and it wasn't defamatory. I'd like to just read the 2 paragraphs that open the California opinion because, number one, they're better written than most court decisions are. And number two, you can see where they're going. Authors write books, filmmakers make films, playwrights craft plays, and television writers, directors, and producers create television shows and put them on the air, or in these modern times, online. The First Amendment protects these expressive works and the free speech rights of their creators. Some of these works are fiction, some are factual, and some are a combination of fact and fiction. That these creative works generate income for the creators does not diminish their constitutional protection. The First Amendment does not require authors, filmmakers, playwrights, and television producers to provide their creations to the public at no charge. Books, films, plays, and television shows often portray real people. Some are famous and some are ordinary folks. Whether a person portrayed in one of these expressive works is a world-renowned film star, a living legend, or a person no one knows, she or he does not own history, nor does she or he have the legal right to control, dictate, approve, disapprove, or veto the creator's portrayal of actual people. Strong, strong language. And now I should just mention two other California cases which are interesting. One which is ongoing is the NCAA athlete name and likeness licensing litigation, where a group of college football players challenged the use of their names and depictions and numbers and uniforms in video games. And the initial ruling of the court was it was not transformative. The second one was a case involving a Simpsons mafia character, which I guess a gentleman who deemed himself to be of the mafia said it violated his right of privacy. And in that case, the California Court of Appeal held that the transformative use defense does apply. New York or California. Now, let me just state that the author or the publisher or whomever does not get to choose what court you end up in. And in today's world where books are sold nationwide and very often sold online, material is distributed online, one may be subject to the law of any one of the 50 states and the District of Columbia. But I should mention, somehow most of these cases end up in New York and California. And a couple of differences. Number one, in governing law, California has a right of descendability for 70 years. It was pushed through originally, I'm told, by the estate of Marilyn Monroe. New York, the liability for taking a right of publicity dies together with the persons whose right has been infringed. Similarly, statute of limitations, New York has a 1-year limitation, California has a 2-year limitation. But I mean, there are things, for example, Indiana has a statute that says that anybody where the infringing material is sold in the state of Indiana can sue there. And Indiana law applies, and Indiana, for example, covers gestures and mannerisms, which is well beyond what both New York and California provide. Now, a few thoughts, and then I guess we'll have questions and answers. Number one, I have concerns, though fewer concerns now, maybe, that to the extent that the law is made in cases involving movies and video games, the concerns of the creators of books and authors and more traditional works may not be considered while the rules are being made. That's point number one. Point number two is you should be careful how your work is going to be marketed. Looking at Spong, for example, if you talk about the true story or the full story, and then it turns out to be more or less fictional, and Spong was really a YA book, a young adult book, and it would be even more so with children's books. It seems to be, it really is important to describe the work, on the work, in the marketing, in a manner that accurately describes what it is. Number three, disclaimers. You all know the usual, any resemblance to actual persons living or dead is purely coincidental. We all know that is generally not true. I mean, very often not true. And again, I would put in a disclaimer, but I would put in a disclaimer that cannot be laughed at. And finally, the issue is, do you get a consent from some of the people, but not from all of the people who were depicted, described? Do you pay some, but not all? That's a closer one. If you have someone that is notoriously litigious, one may want to consider going to the person, or alternatively, and that's my guess is what happened in the de Havilland case, if in fact they got consent from some of the people, they decided that this lady would never give it, so you might as well just avoid it. The question then is, should you have desisted from getting consents to some of the others? Lots of questions. I thank you, and Richard and I'd be happy to try to answer any questions you all have.
Okay, so I know we have a couple questions that have come in, and I'll jump over to those. So anyone, if you have a question right now, there's a little Q&A icon on the bottom of your screen in the toolbar. You can go ahead and open that up and type your question in there, and then that's how we will ask them. And I know we had one emailed in as well, so I'm going to pull that up too. Let's see here. So Robin asked, how is jurisdiction determined?
Jurisdiction is generally determined based on who the plaintiff is who the plaintiff is and where she or he is located, resides, or alternatively where the defendant can be sued. The rules vary, the specifics of the rules vary from state to state.
And generally speaking, a defendant can be sued in any jurisdiction where the activity occurs, so that if one is talking about a book that is published and distributed nationwide, there is at least a risk that one could be sued in any of the states where the book is distributed.
Okay. Okay, the questions are coming in. This is from Lisa. She says, please comment on how a physician author protects herself legally when writing a memoir in which she describes some of her patients. How does she adequately protect patient privacy while still staying in the realm of nonfiction?
That's a tougher one, because what that brings in is not only the issue of a right of publicity, but that brings in other privileges and whether there's confidentiality requirements. The greatest risk there is if somebody can be identifiable from the description of the patient. One obviously can't use the patient's name without the patient's consent, but if the description of the patient is such that the patient could be identified, that is a risky area. I think that probably what is done by many authors in that context is to use composites and to change certain characteristics without changing the underlying story.
There is a case in New York a good while ago called either Roe versus Doe or Doe versus Roe, I forget which way, which involved a book written by a psychiatrist about her patients. And in that court, though it's hard to tell what the ruling is based on because everything was sealed and secret and so on, the appellate division held that the book could not be sold.
Okay. So hopefully that helps with that question. I'm going to just keep rolling along here as they keep piling in. This is from Ran. It says, how does the idea of transformative art apply to a heavily researched and verifiably accurate nonfiction book?
It's not transformative, and it's a verifiably accurate nonfiction book. You should not have to worry about a right of publicity. General rule, the right of publicity has been used when there have been partial fictionalizations and used for the purpose of publicity, where one is using a persona but building on the persona. I'm not aware of any of the cases that apply a right of publicity to a nonfiction book about newsworthy events.
Which sticks to the facts.
That's correct, yeah.
Okay. Roger asked, how are the rights you've discussed changed when the subject is deceased?
The right doesn't change. In those states where the right of publicity is descendable, the issues are the same. You end up with a somewhat more complicated trial because you do not have the case is brought by the estate of the person complaining, and you have a more difficult trial because that person cannot testify as to certain things that happened to him or her.
And in those states where the right of publicity is not descendable, what that means is that the right terminates upon the death of the person that is the subject of the work and who would have asserted the right of publicity, and it can't be asserted by the estate.
Okay. Valerie asks, I've written a memoir about my years singing in a band, which includes names and photographs. This all happened 50 years ago. I had an attorney tell me because of the time frame, I would not need to worry about using names and photographs. All 6 of us are living in different states now. I'm in contact with 4 of the members, but cannot find 2 others.
One thing that I should say, we do have a disclaimer at the bottom of the screen that's now before you, and we're hesitant to provide specific advice on very specific factual scenarios. But one of the issues that's presented by that situation like that is whether you treat people disparately or not. One of the problems in the de Havilland case, a problem that ended up being dismissed by the Court of Appeal, but one of the reasons why the trial court had ruled in de Havilland's favor is that, at least according to the record in the trial court, and there was some question about it, the producer had paid some persons who were depicted in the film, but not others, and that was led to at least an impression, although not the law, that there was a requirement to make such payment. The Court of Appeal decision in de Havilland clearly stated that there was no requirement to make the payment. The basic advice in that situation is, to the extent possible, treat the persons who are going to be depicted or written about in the same way. If one is seeking consent from some, one should seek consent from all. If one is not seeking consent and just publishing as of right, one should do that in a consistent manner to the extent possible.
And I mean, the other point, which is moving sort of from the right of publicity to the right of privacy, to the extent that the author discloses facts which are related to the privacy of one of the band members, what happened in the back room, and so on. There may be a whole range of different issues.
Okay. So this is also about bands and musicians. Cheryl asked, can you use band names, musician names, and how about song lyrics?
I'm sorry, the last part. Band names, musician names, and how about?
Song lyrics.
Song lyrics. Well, song lyrics, you're raising a copyright question, and there it depends upon your proposed use of whether the proposed use is a fair use, and that's an entirely different subject matter. Could you use a band name? Could you use in a work? The statutory right of publicity in New York applies to persons, not to organizations, and thus one could use a band name without. It's likely that one could use a band name without potentially treading on a violation of the statutory right of publicity in New York. There may be states that with a more expansive view, where as long as one could identify the individuals from the band name, then it would come into play. And also, it also depends, obviously, on what we're talking about is the rest of the work. Is this a fictionalized account? Is this a nonfiction account, et cetera?
Okay. Linda Hunter asks, when writing a memoir, if the facts put a family member in poor light, what is the author's legal standing if that person wants to sue?
I didn't understand the first part of the question.
When writing a memoir, if the facts put a family member in poor light, what is the author's legal standing if that person wants to sue?
Well, it gets back to, again, to what extent are the facts, I mean, if they're not clearly facts in states which have false light privacy rules, you may have issues. To the extent that it is defamatory, you certainly will have issues. And though I should mention, whenever anybody asks me, can they sue, the answer always is yes. The issue is whether they're going to win.
All right. We have a couple more coming in. This is from Marilyn. She said, you addressed physicians writing about their patients. What about patients writing about their physicians?
I'm not aware of any special right that a physician has that protects information that a patient would have about the physician's treatment of the patient. So that, at least to my knowledge, that issue does not get layered on top of this. And otherwise, one would have the same issues that would arise in any other subject of the work.
Okay. Now this next one is a little detailed as well, so I don't know if you guys will be able to answer it, but I'll ask you anyway, just in case you can give some advice here. This is from Robin. She says, I've written a play about Katherine Graham and her husband, both deceased, of course. It's about his abuse of her, which is referenced in her biography and other books. The play imagines the details of that part of her life and her thoughts about it. I have a disclaimer saying this is a work of fiction drawn from the life of Katherine Graham and based on my book about her. Is this sufficient for any claim of defamation, right to publicity by the family? And then she goes on to say, this play has not been produced but is being sent to theaters. Does this distribution place me in jeopardy, and should I get insurance?
Well, the answer to the last question is yes. I mean, because one can't answer that question really without reading the play and going into to what extent are there verifiable facts, to what extent are there assumptions, etc.
It's too specific that I don't want to answer directly. I will say that it does pose that description sounds as though one were writing a law school hypothetical to present the issue for this webinar on right of publicity, because it puts at issue exactly a contrast between the Warren Spong story and 6 Degrees of Separation, which are both fictionalized accounts of real persons and real events, one of which led to, in the Warren Spong story, a cause of action on behalf of Spong against the publisher, and the other with 6 Degrees of Separation, a decision upholding the creative work. So it does squarely present the issue. Unfortunately, it's easier to present the issue than to answer the question, and one would need to dig much deeper into the facts to find out, to make a judgment on it.
Okay. It looks like we have one more. This is from Lisa. She said, I'm writing historical fiction based on the story of a real set of sisters who are long dead and had no heirs. What other issues should I be thinking about in these circumstances?
Getting it published and sold.
All right. Any other answers there, or anything else you guys?
That obviously is a semi-facetious answer. It's not facetious in the sense that we wish authors luck. It is facetious in that it obviously doesn't address the right of publicity. There is a descendable right of publicity in some states, not in other states. If there are no heirs, the chance that anybody could step forward and assert a descendable right of publicity, even if there were, even if one was under a state law that recognized such a right, would obviously become remote. There would be a question as to, I assume the heirs refers to natural heirs, children or grandchildren. I don't know whether in any of the states that recognize a descendable right of publicity, the beneficiary of a will of all of the rights of the decedent could assert such a right. But that might be a possibility that one would have to look into before coming to the conclusion, in fact, that there were no heirs who could assert a descendable right. But it seems to me that if one were to put on a scale of risk, that situation with the Katherine Graham situation, the Katherine Graham situation raises far more questions than this does.
Okay, excellent. We did have one more question pop in as a follow-up question from Robin about getting the insurance. She said, should I get insurance before the play has been accepted for production?
My very practical view is you don't need insurance. you don't need insurance until the play is either produced or published. So it's not going to cost more than it costs now.
But obviously, you do want the insurance before there's any risk that you know that there's a threat. Because if there's even if it's before publication, once you receive a threatening letter, that's going to be something that an insurance company or potential insurance company is going to want to know about. So the answer should be, Michael's response is don't do it too early because it's a waste of money. And my response, which I agree with Michael, but I add, don't do it too late, particularly if you think a threat may materialize, but none has materialized.
Particularly to agree with Richard on the other end of the spectrum, generally publishers insurance provides that they pay for defense counsel. And therefore, you want to have that in place before somebody threatens you with anything so that you can use a lawyer that the insurance company pays for.
Okay. So I think that wraps up our Q&A. That's the end of the questions. This was very informative, very helpful. Thank you guys for taking the extra time to answer the questions for everyone who popped in for that part. Thank you everyone for joining us, and thank you Michael and Richard for all of your help today.
It's our pleasure. Thank you very much.
Thank you guys. Bye-bye.
Okay. Bye-bye.